Owen broke into a Delray Beach home in 1984, attacked and killed a then 14-year-old while she was babysitting.
The execution of death row inmate Dwayne Owen is happening next month.
If his execution does move forward,
Governor Ron DeSantis has now dissolved and terminated a temporary stay of his execution.
He'll become the third person in Palm Beach County convicted of murder to be executed by the state.
He's now scheduled to die by lethal injection on June 15th.
2 months later, he broke into a Boca Raton home and killed a 38-year-old mother.
This case is under a death warrant with an execution pending. Doesn't mean
I will render written orders, as I've already indicated just a moment ago, as quickly as I can, but in no event.
After 3 decades, an ending warrant may be near for Palm Beach County's most notorious slayer. We look back at the case of Dwayne Owen that still haunts our memories. The Monster. On June 1, 1961, Dwayne Owen, also widely known as the Monster, was born in Jacksonville, Florida. The city is located in the United States. We'll investigate Dwayne Owen's early years and the reasons that may have contributed to his aggressive behavior later in life.
Governor DeSantis putting a temporary hold on a death row inmate with ties to South Florida till after 3 psychiatrists evaluate the 62-year-old inmate. The governor issued an executive order to temporarily stay Dwayne Owen's execution. Yesterday, the state Supreme Court set up an expedited schedule to hear appeals in the case,
in order to gain a better understanding of his past and his youth. Owen's childhood was characterized by a turbulent familial environment, which had a significant impact on his development. When he was a young child, his parents went through a divorce, which caused unpredictability and upheaval in his household. According to the reports, Owen spent a significant portion of his formative years dealing with both physical and emotional abuse. These traumatic experiences from his childhood may have had a significant influence on his psychological development and may have been a contributing factor in his subsequent criminal behavior. Owen exhibited symptoms of behavioral problems as a child and had difficulty performing well in school. He was said to have trouble managing his impulses and frequently engaged in behavior that was hostile towards other children. These early warning signs of antisocial inclinations and a lack of empathy are typical of people who go on to demonstrate violent tendencies later in life. Owen's problems only got worse as he got older, particularly during his teenage years. He was involved in a wide variety of illegal pursuits and had numerous run-ins with law authorities. Theft and burglary and drug-related offenses were all listed on his rap sheet as charges against him. Owen's run-ins with the authorities were a precursor to the pattern of criminal behavior that would culminate in the horrible acts he committed. Owen had already developed a hardened criminal mindset by the time he reached the early years of his 20s. His propensity for violence grew stronger, and he started engaging in more horrific deeds as a result. Crimes conducted. Dwayne Owen, commonly referred to as the Monster, committed a series of horrific crimes that terrorized the Boca Raton area of Florida between 1984 and 1986. His acts of violence included slaying, physical attack, and burglary, leaving a trail of devastation and fear in the community. Owen's first known crime occurred on May 27, 1984, when he broke into the home of Karen Slattery, a 14-year-old girl who lived in Boca Raton. Owen entered her residence through a window and attacked her while she slept. He proceeded to physically attack and strangle her to demise. Slattery's brutal slaying sent shockwaves through the community, leaving residents on edge and authorities scrambling to find the perpetrator. Following the slaying of Karen Slattery, Owen continued his reign of terror. On August 4, 1984, he targeted another young girl, 14-year-old Georgiana Warden. Warden was abducted from a shopping mall parking lot in Delray Beach near Boca Raton. Owen forced her into his vehicle at knife point, blindfolded her, and drove her to a remote area. There, he physically attacked and slayed her, leaving her lifeless body in the bushes. Owen's crimes escalated in brutality and audacity. On December 29, 1984, he targeted a family home in Boca Raton, where he broke in and attacked 2 sisters, Lynn and Cheryl McGrath. Owen bound the sisters with duct tape, physically attacked them, and then proceeded to knife them multiple times. Cheryl, only 8 years old at the time, tragically succumbed to her injuries and died. Lynn, who was 23, miraculously survived the attack and provided crucial information to the authorities in their efforts to identify the perpetrator. The community lived in fear as Owen continued to elude capture. His next victim was a 14-year-old girl named Kathleen Briles, whom he encountered on March 29, 1985. Owen abducted her from her home in Boca Raton, physically attacked her, and then strangled her to demise. Her lifeless body was found abandoned near a canal. The final known crime attributed to Dwayne Owen occurred on May 27, 1986, exactly 2 years after his first slaying. He targeted another family home where he broke in and attacked a mother and daughter. The mother, Sharon Peoples, managed to escape and seek help, but her 14-year-old daughter, Loretta, was physically attacked and slayed by Owen. Despite the terrifying nature of Owen's crimes, it was the use of emerging forensic techniques and DNA analysis that ultimately led to his arrest.
Remains on death row. Dwayne Owen is scheduled to be executed next month, sexually assaulting a teenage girl in Delray Beach and then killing another woman in Boca Raton in 1984. This will be the 4th execution in the state of Florida this morning. Attorneys on both sides were back in Palm Beach County Court.
Authorities were able to connect Owen to the crimes through DNA evidence found at the crime scenes. On July 1, 1986, he was apprehended and taken into custody. During his trial, the shocking details of Owen's crimes came to light, painting a disturbing picture of his brutality.
Owen broke into a Delray Beach home in 1984, attacked and killed a then 14-year-old while she was babysitting.
Owen killed a 14-year-old babysitter and a mother of 2 in Palm Beach County nearly 40 years ago.
2 months later, he broke into a Boca Raton home and killed a 38-year-old mother.
The execution of death row inmate Dwayne Owen is happening next month.
If his execution does move forward,
Governor Ron DeSantis has now dissolved and terminated a temporary stay of his execution.
he'll become the 3rd person in Palm Beach County convicted of murder to be executed by the state.
He's now scheduled to die by lethal injection on June 15th.
It was revealed that Owen had meticulously planned his attacks, targeting vulnerable victims and resorting to extreme violence. He showed no remorse for his actions and demonstrated a complete disregard for human life. In October 1986, Dwayne Owen was found guilty of multiple accounts of slaying, physically attacked, and burglary. The jury recommended the ending penalty, and Owen was initially sentenced to demise. However, in 2002, Florida's ending penalty was ruled unconstitutional, leading to Owen's sentence being commuted to life in prison without the possibility of parole. Statement of the case and facts. The state provides its own statement of the facts as follows. On March 24, 1984, Carolyn Slattery dropped off her daughter Karen Slattery at the Helms residence around 6:30 p.m. Karen was described as having an athletic type build, had a special talent, and liked to do people's hair. Mrs. Slattery also testified that after the braces were removed, Karen was required to wear a retainer. William Helm, the owner of the home where Karen's body was found, testified that on March 24, 1984, he and his wife went out and left their 2 daughters with Karen Slattery to babysit the 5- and 9-year-old girls. When he returned home shortly after midnight, he noticed the lights in the living room, except for one, were turned off, the television set was off, and other lights in the kitchen were on. The most important details in this case are the 3 motions to suppress evidence related to the slaying of Karen Slattery. The first motion to suppress, SR 25, sought to suppress the statements of appellant alleging lack of probable cause, reasonable grounds to believe and founded suspicion, but the initial stop which led to appellant's arrest. The second motion to suppress, SR 2-6, alleged appellant did not make a voluntary, knowing, and intelligent waiver of his rights, nor were the statements freely and voluntarily given due to the psychological coercion exercised on appellant by the manner the officers obtained the statements from appellant. The third motion to suppress, SR 8-9, alleged selectively recording portions of appellant's statements, denied appellant access to exculpatory material, and otherwise rendered the remaining recorded portions untrustworthy. On the 28th of May, 1984, Boca Raton was investigating a burglary at Dumille Gorman's home, 640 Lakeview Terrace. Officer Brady spoke to Miss Gorman and showed her a photo lineup which included a photograph of appellant. The slaying of Georgiana Warden was reported May 29, 1984, and the police were looking for Dwayne Owen prior to May 30, 1984. Investigator Kathleen Petracco testified that the Boca Raton Police Department was involved in the investigation of the Georgiana Warden slaying, and that on May 30, 1984, Sergeant McCoy gave her a photograph of appellant with instructions to keep an eye out for him. On May 30, 1984, at 12:30 p.m., Officer Petracco saw someone who matched the description given to her as that of Dwayne Owen. Lieutenant Kevin J. McCoy testified that due to 3 outstanding and active warrants for Dwayne Owen, and the fact Dwayne Owen was suspected of committing the burglaries against Sasko's property and Gorman's residence, a bulletin and a bolo. The most important details are that when McCoy arrived at the scene, he saw the person look just like the photograph and was sure this was Dwayne Owen. After hearing the evidence and arguments by counsel, the trial court denied the first motion to suppress, finding that there was probable cause and a basis for the stop and arrest. On the second and third motions to suppress, the trial court found that the arrest was based on probable cause, and Owen had been properly advised of his constitutional rights. After appellant was arrested, a search warrant was obtained and Detective John Barrett searched appellant's apartment at 501 NE 45th Street, Boca Raton, Florida. Detective Brady retrieved a name tag with the name of Brown on it, a second military name tag with the name Owenel on it, and a rolled pair of socks. During the conversation of June 18, 1984, appellant refused the request to take his footprints, and Captain Lincoln obtained a court order for the footprints. According to the details, appellant cut the screen with a knife and went into the bedroom by jumping through the window and tumbling down on the bed. Owen opened the door, heard some noises, and walked over to the sliding glass 010 doors and peeked into the living area where he saw Karen and 2 kids laying around the floor. Owen then left the house through the window again, closing up to make it look like no one had come in. He then went back to the Gipper Lounge and had some drinks, and after 2 hours went back to the Helms residence. Owen also admitted to getting a pair of gloves from the closet and a hammer from the toolbox in the closet. He then went back to the master bedroom and scoped through the screen, the patio area, and just scooped it out. He could see Karen's legs as he was watching TV. Owen looked through drawers in the bedroom but could not find any jewelry. Owen noticed Karen Slattery still watching television on the floor. She got up to check on the kids, and when she turned around and saw Owen approaching, he grabbed hold of her and tried to get the phone away. In the struggle, Owen knifed her in the back. Karen fell to the floor and did not fight back or speak. Appellant, Owen, confessed to the police on June 22, 1984, that he had hidden gloves, shorts, and socks in the back area of the Helms home. The forensic serologist Richard Tanton testified that Owen had type O non-secretor blood, while Karen had type A secretor blood. The blood samples were compared for evidentiary purposes. Tanton found evidence of type A blood with weak 0 material, indicating that the possible contributor was either an A secretor or a non-secretor. The gloves tested negative, but the 2 socks showed a luminal reaction consistent with blood. Owen's footprints were also found at the Helms residence. Dr. Jerson M. Perry, a podiatrist, compared the footprints to Owen's prints and identified a similar pattern. The trial court denied motions on counts 1 and 3 but reserved ruling on count 2. The defense then rested without Owen testifying personally.
Today in Palm Beach County Court, attorneys on both sides discussed this year and only the 6th under the direction of Governor Ron DeSantis. While the Attorney General's office says they provided public records between 1995 and 1997, public record requests detailing clemency from Dwayne Owen's team. And the judge ordered any additional records Owen's teams have not received today. According to court records, Dwayne Owen broke into a Delray Beach home in March of 1984 to be sent over to them no later than 4 p.m.
The state argued that the trial court should not reserve ruling on the motion for judgment of acquittal on count 2. The trial court granted the defense's requested jury instructions regarding whether Karen was already dead at the time she was physically attacked. The jury found Owen guilty on all 3 counts. During the autopsy, Dr. Frederick Hoban, the medical examiner, revealed that Karen had suffered 18 knifing and cutting injuries, with 7 of the knifing injuries being fatal. Her 11 lungs were damaged, impairing her respiratory functions and causing her to gasp for air violently. The loss of blood initially caused unconsciousness and eventually demise. Evidence presented at the trial included testimony from J. Patrick Peterson, Ph.D., and Mitchell Ray Owen, appellant's brother. The jury rendered an advisory sentence of demise via vote of 11-1.
Once inside, he repeatedly stabbed and killed a 14-year-old who was babysitting 2 kids. He attacked her with a hammer, raped, and killed her. Dwayne Owen's execution is set for June 15th. About 2 months later, Owen broke into a Boca Raton home where a 38-year-old woman was sleeping. That's scheduled for 4:30 p.m. And we're told attorneys will be back here at the Palm Beach County Courthouse on Thursday for another hearing.
The trial court identified 5 aggravating factors and found no mitigating circumstances that outweighed the aggravating ones, resulting in a demise sentence for Owen. Mitchell Ray Owen provided testimony about appellant's childhood and general background. Owen had been diagnosed with both antisocial personality disorder and schizophrenia disorder. Despite his mental health conditions, the court determined that Owen had the mental capacity to formulate the intent to slay. Ultimately, the jury's advisory sentence of demise and the trial court's findings of aggravating factors led to Owen being sentenced to demise. Summary of the argument. The most significant aspects of this case are the fact that the evidence wholly supports the finding that all of the components of a physical battery were proven beyond a reasonable doubt, and that the trial court did not make a mistake in refusing the petition for judgment of acquittal with regard to count 11. The evidence that the defense attempted to adduce by cross-examining Officer Pellegrini was found to be irrelevant and extremely speculative to be admissible by the trial court.
3.851 motion filed on behalf of Mr. Owen. I've read the post-death warrant, and I've also read the state's response in opposition entitled Fourth Successive Motion to Vacate Judgment of Conviction and Sentence of Death. The hearing is necessary or warranted to that motion, and based on the arguments advanced in those 2 submissions, I find that no evidentiary and appearance of Mr. Owen before this court is not required. I will issue a written order to that effect so that the Department of Corrections is advised that they will not be transporting Mr. Owen to this courthouse this afternoon. In determining the 3 additional motions made on Mr. Owen's behalf tomorrow, I'm likewise quite comfortable exclusively on the written submissions. However, concerning competency, diagnostic scans, and stay of execution, to reiterate any of those arguments that they've already made, if either side feels it necessary, in their written submissions, I will give both sides a few minutes within which to do that today.
And that the ruling of the trial court may not be disturbed because the appellant has not shown that the judge abused his or her discretion in any way. Finally, the review determined that the lower court's decision regarding the appellant's motion for judgment of acquittal in regard to count 11 was correct. In addition, the other aspects of this case that are the most utmost significance are the fact that the sentencing order issued by the trial court was founded on the evidence that both supported both the aggravating and mitigating elements, and that the penalty that was handed down was death.
So let me start with Mr. Owen's team.
And just to verify, you don't want me to address anything in the fourth successive motion. Lisa Fusaro on behalf of Mr. Owen.
And I've seen the responses by the state in opposition to all 4.
And just the other motions.
Well, I don't need you to address any of the 4 motions, frankly, because I've read them all. Advancing those arguments again, taking into consideration the fact that I've already read. But if you want to give, spend a little time giving it the expedited handling that I've been instructed by the Supreme Court to do since last weekend, the motions and the responses, and I've been looking at this case. So I feel fairly confident in my ability to be able to rule based on the written submissions.
It is crucial that the criteria for admissibility of evidence was applied and that Dr. Peterson's testimony describing appellant's personality abnormalities was heard by both the jury and the trial judge. The testimony of the victim's mother was pertinent to the evidence that indicated appellant committed the homicide, and the trial court did not make a mistake in admitting the evidence at trial since it was relevant to corroborate the evidence that showed appellant did commit the slaying.
Okay. The main thing I'd like to address would be the motion for determination of competency to proceed, being that it's with all of his fixed delusions and he keeps proceeding on certain, certainly that's the most important motion that we have, because that affects everything else and trying to do everything under warrant in this accelerated process. Certain things, it's very hard to actually communicate about trying to do the case, and I feel like there likely is, but without So, it's hard to determine, is there other newly discovered evidence that maybe we need his input for? Severe mental illness and schizophrenia, and the fact that he doesn't really want to talk about being able to communicate with him properly about all of that based on his, and we really feel like since everything has been declining and, the things we need to talk about in this posture, it really becomes very difficult. And the fact that he had also said that he is incompetent to be executed, we really feel like more experts, we feel he's incompetent to proceed based on Dr. Eisenstein's report, need to determine what is going on with his competency.
The Honorable Court and the United States Supreme Court have concluded on several instances that the Constitution does not preclude the states from demise qualifying juries in situations involving the ending penalty. The trial court did not abuse its discretion or make an error that can be overturned when it denied the appellant's proposed instructions to the jury.
And I feel like we really need to go forward with that side of things. So that would be my biggest argument. Do deny giving him all of, I know the state has brought up some case law, but I feel like if we, giving him the determination and for his competency, in essence, we're almost making a blanket statement. And the case law doesn't say that, and neither does the rule. It's saying that if you're in a warrant posture, that it doesn't matter whether you're competent to proceed or not.
The usual jury instructions should be used wherever they are deemed suitable. On a direct appeal, the question of whether or not a defendant received adequate representation by counsel cannot be brought up for the first time. Appeals filed by Dwayne Owen. Dwayne Owen, the convicted serial slayer known as the Monster, has made several appeals to the court seeking release or a reduction in his sentence. These appeals have been based on various legal arguments and grounds, each aimed at challenging his conviction or sentence. However, until 2021, Owen appealed to the court on different occasions and changed the respective information many times just to be released, but that didn't help in any way. One of Owen's significant appeals took place in 1993. At the time, he sought post-conviction relief, arguing ineffective assistance of counsel during his trial. He claimed that his defense attorneys failed to provide adequate legal representation, which violated his constitutional rights. However, this appeal was denied by the court and Owen's conviction and sentence remained intact. In 2006, Owen filed another appeal challenging his demise sentence. His legal team argued that Florida's method of ending by lethal injection amounted to cruel and unusual punishment, violating the 8th Amendment of the United States Constitution. Additionally, they claimed that the trial court had failed to consider certain mitigating factors during the sentencing phase. However, the appeal was unsuccessful, and Owen's demise sentence was upheld. In subsequent years, Owen pursued additional legal avenues to challenge his conviction. One such attempt occurred in 2010 when he filed a motion for post-conviction DNA testing. He requested that new DNA testing be conducted on the evidence from the crime scenes to potentially identify any unknown perpetrators. However, the court denied this motion, ruling that Owen failed to meet the legal standards required for post-conviction DNA testing. In 2012, Owen made another appeal, this time challenging the constitutionality of Florida's ending penalty sentencing process. The appeal was based on the United States Supreme Court decision Ring v. Arizona, which held that juries, rather than judges, must make the factual determinations necessary for imposing the ending penalty. Owen argued that his demise sentence was unconstitutional because the judge, rather than the jury, made the final sentencing decision. However, the court rejected this argument, stating that the decision in Ring did not apply retroactively to Owen's case. In addition to these major appeals, it's possible that Owen may have filed other motions or petitions at different stages of his legal proceedings. However, specific details regarding every filing and its outcome may not be readily available.
All right, so I'll give you a few minutes. How much time do you need to do that? I've read the legal authorities cited in the motion, and I've read the response that I got last night. Again, once again, just so the record is crystal clear on this point, I have read the motion already, and I'm prepared to make a decision from the state on that response to that particular motion as well. So, and I'm not saying, by the way, that I'm going to announce that right now. I want to digest all of it carefully and orders based on or determining all four of the motions. My plan is to issue or to render in no event later than 3 o'clock tomorrow, because that is my deadline, the deadline imposed upon me by the Supreme Court, quickly as I can in accordance with the Supreme Court's mandate. But the bottom line is I'm not going to rule from the bench, but I will hear additional argument if you feel it's necessary. So I don't know if that makes it any clearer for you. I'm not going to...
Despite his efforts, Dwayne Owen has been unsuccessful in securing his release or obtaining a reduction in his sentence through the appeals process, as after all his attempts to file appeals, in September 2021 he remains incarcerated and serving a life sentence without the possibility of parole for his heinous crimes.
Your Honor, that was most of the argument right there. We stand on our pleadings, but
Gotcha.
you make that known. This obviously is a huge deal, and I think that you should point the just in the case, but that was not clear in the motion.
Okay.
I just wanted to.
And
Just
then,
briefly, Your Honor.
there you go. And for the record, make sure you announce who you are.
Yes, sir.
Of course, it's a huge deal. All right, for the state, Ms. Terenzi, go ahead.
Celia Terenzi on behalf of the Attorney General's office. I would only add that simply because the case law or the rules of procedure do not apply to Mr. Owen or to this motion. This case is under a death warrant with an execution pending doesn't mean...
I will render written orders, as I've already indicated just a moment ago, as quickly as I can, but in no event.
That's all I have to say.
Very well, thank you. Okay, so then hearing nothing else, will the last order come out of my office after 3 o'clock p.m. tomorrow, so that I am in compliance with the Supreme Court's order. I will have ruled on all 4 motions before that. So if there's nothing else, and I have nothing else, I can tell you that. If there's nothing else from any of you, I've got plenty more to do. I'm prepared to adjourn for the day, at least in the courtroom. All right, hearing nothing, we are adjourned. Thank you, folks.
Delay and ending for Dwayne Owen. Dwayne Owen, 62, temporary stay of ending has been dissolved and terminated by Florida Governor Ron DeSantis. The Demise Row inmate is once again scheduled to die by lethal injection on June 15th, making him the 4th person to be executed by the state. Nearly 40 years ago, Owen slayed a 14-year-old Delray babysitter and a Boca Raton mom of 2 in separate attacks. In May 2023, DeSantis issued an executive order in response to a request made by Owen's attorneys for a psychological evaluation to determine if Owen's mental state could exempt him from lethal injection. The executive order came only 1 week after the governor signed off on Owen's ending and stated that the governor claimed the allegations of Owen's mental health were not sufficient to claim insanity. But DeSantis greenlit the evaluation because his solemn duty to execute a duly imposed sentence of demise required the exercise of utmost caution. On May 25th, just 3 days after DeSantis approved a temporary hold on Owen's ending penalty date, the governor issued another executive order dissolving that action. The psychiatric evaluation that his attorneys ordered revealed that his current mental state is coherent enough for him to understand the reasoning behind his sentence. Quote, "The commission has completed its examination of Dwayne Eugene Owen," the executive order said, and has concluded that Owen has the mental capacity to understand the nature of the ending penalty and the reasons why it is to be imposed upon him, end quote. Dwayne Owen is once again scheduled to be put down by lethal injection on June 15th at 6 p.m. if Florida values life. According to some Jewish believers, this law is not right. Florida Governor Ron DeSantis has issued a temporary stay of ending to allow psychiatrists to assess the sanity of Dwayne Owen, who was scheduled to die by lethal injection on June 15th. The governor's original signing of Owen's demise warrant came just days after he signed into law a bill that allows for the ending penalty for perpetrators of physical violence against children in Florida. The thousands of members of Lasham Jews Against the Ending Penalty believe this law is wrong and would be wrong to eventually execute Dwayne Owen. Dwayne was born to alcoholic parents and was emotionally and physically hurt as a child. This led him to a life of crime, culminating in the heinous physically attacked and slaying of Karen Slattery and Georgiana Warden. DeSantis sought to perpetuate the same cycle of violence and demise that he claims to hope to end through the wanton political pursuit of barbaric laws allowing for state-sanctioned slaying. The ending penalty has failed to deter crime, instead creating new victims, including those put down, their loved ones, and Lashane is an organization that opposes every ending, including the case of Robert Bowers, who has been charged with the October 2018 shooting demise of 11 Jewish worshippers at the Tree of Life Synagogue in Pittsburgh, Pennsylvania. Their opposition to state slaying is grounded in the fact that many of them at Lashane are direct descendants of Holocaust survivors, such as Eli Wiesel and Martin Buber. Their Jewish tradition teaches them that whoever and whatever destroys a life is considered as if he destroyed an entire world, and whoever saves a life is considered as if he saved an entire world. If the state of Florida professes to be pro-life, then the planned state-sponsored slaying of any defenseless human being should be anathema. Impact on the government. Dwayne Owen's crimes had a profound impact on the government at various levels, from local law enforcement to legislative initiatives. His actions highlighted the need for improvements in law enforcement practices, victim advocacy, and criminal justice policies. Here are some of the key impacts his case had on the government. Number 1. Law enforcement practices. The investigation into Owen's crimes exposed the need for enhanced forensic techniques and DNA analysis. The use of emerging technologies played a crucial role in connecting Owen to the crimes and securing his conviction. The case prompted law enforcement agencies to prioritize the development and implementation of advanced forensic methods to solve complex criminal cases. Number 2. Victim advocacy and support. The devastating nature of Owen's crimes highlighted the importance of providing comprehensive support and services to victims and their families. The government, in collaboration with nonprofit organizations and victim advocacy groups, worked to improve victim support programs, ensuring that survivors of violent crimes receive the necessary assistance, counseling, and legal advocacy throughout the legal process. Number 3. Legal reforms. The high-profile nature of the Owen case spurred discussions and reforms in various areas of the legal system. It prompted legislators to review and update laws related to sentencing, parole, and capital punishment. Owen's case contributed to debates surrounding the ending penalty and its application, leading to legislative changes and potential re-evaluations of sentencing practices. Number 4. Public safety measures. The community's fear and outrage following Owen's crimes prompted the government to implement measures to enhance public safety. Law enforcement agencies increased their presence and implemented strategies to improve crime prevention, including community policing initiatives and neighborhood watch programs. The government also worked to improve communication and cooperation between different agencies to facilitate a more coordinated response to criminal activities. Number 5. Mental health considerations. Owen's case highlighted the intersection of mental health issues and criminal behavior. His diagnosis of antisocial personality disorder and schizophrenia disorder raised questions about the treatment and management of individuals with mental health conditions within the criminal justice system. This case prompted discussions on the need for comprehensive mental health evaluations, appropriate treatment, and the provision of mental health resources in correctional facilities. And finally, number 6, awareness and education. The media coverage of Owen's crimes increased public awareness of the impact of violent crimes on individuals and communities. This heightened awareness led to educational campaigns aimed at preventing violence, raising awareness about personal safety, and fostering a culture of reporting suspicious activities. The government, along with community organizations, initiated programs to educate the public about crime prevention, self-defense, and recognizing signs of potential danger. Overall, Dwayne Owen's crimes had a significant impact on the government, spurring reforms and initiatives aimed at improving law enforcement practices, victim support systems, legal reforms, public safety measures, mental health considerations, and public awareness. The case served as a catalyst for change, leading to a re-evaluation of existing policies and practices in the criminal justice system to prevent similar tragedies in the future. Mental health and delay in putting down. Mental health can play a significant role in delaying the ending of criminals through various legal and ethical considerations. The recognition of mental health issues in capital cases has led to important legal developments that take into account the mental state of individuals facing the ending penalty. Here are some keys in which the mental health can contribute to delays in the ending process. Number 1. Competency to be slayed. Before an ending can proceed, the condemned individual must be deemed competent to be executed. Competency refers to the mental capacity of the individual to understand the nature and purpose of the punishment they are about to face. If a person is found to have a severe mental illness or intellectual disability that impairs their comprehension of the situation, it may result in a delay or stay of ending. Number 2. Mental illness as a mitigating factor. In some jurisdictions, mental illness is considered a mitigating factor in capital cases. When a defendant's mental illness is presented as evidence during sentencing, it can be used to argue for a lesser punishment, such as life imprisonment, instead of the ending penalty. The process of examining and presenting evidence related to mental health can lead to delays in the ending as the legal system carefully evaluates the impact of the mental illness on the individual's culpability. Number 3. Eighth Amendment considerations. The Eighth Amendment of the United States Constitution prohibits the use of cruel and unusual punishment. In the context of the ending penalty, the Supreme Court has ruled that it is unconstitutional to execute individuals who are intellectually disabled or have certain severe mental illnesses. Determining whether an individual meets the criteria for exemption based on their mental health can involve extensive legal proceedings and evaluations, leading to delays in the slaying process. Number 4. Mental health evaluations and appeals. In capital cases, mental health evaluations may be conducted to determine the defendant's mental state and potential mitigating factors. These evaluations involve experts in the field of psychiatry or psychology, assessing the individual's mental health history, disorders, or other conditions. The presentation of such evaluations as part of the appeals process can contribute to delays as the defense and prosecution argue over the significance and interpretation of the findings. Number 5. International human rights standards. In many countries, adherence to international human rights standards is essential in the application of the ending penalty. International bodies and organizations often express concerns about executing individuals with mental health issues, arguing that it violates their human rights. These concerns can lead to diplomatic pressure, international scrutiny, and legal challenges, resulting in delays in the putting down process. And number 6, evolving understanding of mental health. Over time, society's understanding and awareness of mental health have evolved. There is increasing recognition of the complex interplay between mental illness, cognitive impairments, trauma, and criminal behavior. This evolving understanding has influenced legal systems to take a more nuanced approach to individuals with mental health issues in the criminal justice system, potentially resulting in delays and endings as new legal arguments and considerations emerge. It is important to note that the application of mental health considerations in capital cases varies across jurisdictions, and the specific legal standards and procedures differ as well. The impact of mental health on delaying endings is influenced by legal frameworks, judicial interpretation, and evolving societal attitudes toward mental health and punishment. Final thoughts. When examining the past and childhood of Dwayne Owen, it is necessary to recognize that although some environmental variables and early experiences may have played a role in molding his behavior, they cannot completely explain his actions. This is something that must be acknowledged in order to really understand Dwayne Owen. Even after enduring a challenging childhood, a significant number of people do not go on to commit violent crimes. It is difficult to pinpoint a specific reason for Owen's monstrous behavior because of the intricate interplay between genetic predispositions, personal choices, and environmental circumstances. Despite this, it is undeniable that Dwayne Owen's turbulent upbringing, which was characterized by the instability of his family, the pain he endured, and his early involvement in criminal activities, all contributed to a downward spiral that, in the end, led to his status as a legendary serial killer. His case serves as a reminder of how important it is for society as a whole to address issues such as child abuse, mental health, and the early intervention and rehabilitation of damaged persons in order to avoid the kind of disastrous outcomes that he experienced. The atrocities committed by Dwayne Owen had an enduring and far-reaching effect on the town of Boca Raton and beyond. They brought attention to the fact that forensic procedures and DNA analysis need to be improved in order to be used effectively in investigations of criminal activity. The case brought to light the significance of addressing issues relating to mental health, early intervention, and rehabilitation, among other related topics. Owen's name appears in a number of reports that are written in a faded brown. Officers who were involved in the incident have either retired or moved on, but that does not mean they have forgotten about him. Owen is responsible for a number of atrocities, yet none of them will be tied to him. Nevertheless, the record is frightening enough. Obviously, Owen's killing spree had the potential to be far more horrific. If he had not been captured in 1984 when it is suspected that he was leaving the city, there is no doubt in anyone's mind that he would have attempted another murder. Despite this, he tried to break into a great number of other houses, but he was either unsuccessful or stopped. During the slaying scenes, he did not kill any of the children. And that's all for this video, folks. We'll see you at the next one next time.